friends, my name is Mashood Iqbal. I'm a barrister at London View Chambers, and today I will talk about bail in immigration matters. If a non-European national who does not have leave to remain in the United Kingdom, or even a European national who is subject to a deportation order by the Home Office, is taken into immigration detention, then they can apply to the first-tier Tribunal of Immigration and Asylum Chambers to be released on bail. Bail application form need to be completed and grounds of bail application also need to be drafted. You have to provide detail of your sureties, although by law you're not required to provide sureties, but it's very unlikely for a first-tier tribunal judge to grant you immigration bail without sureties. So you can provide details of either one surety, two sureties, or even more than that. And you have to provide details of your sureties, their names, addresses, immigration status in the UK, dates of birth, employment status or self-employment status. You have to provide certain documentation along with your bail application, such as copies of their passport or immigration status document, salary slips, bank statements, utility bills, tenancy agreement, letter from accountant or previous year's annual tax returns, etc. So once the bail application is completed, it then needs to be sent to that hearing centre of the first-tier tribunal that is situated closely to the detention centre where the applicant is detained. Once the first-tier tribunal receives a bail application form, then it forwards the bail application form to the Home Office, and in response the Home Office prepares a bail summary. That bail summary needs to be sent to the tribunal and also to yourself, to your solicitor, to your barrister, to your legal representative 24 hours in advance of the bail hearing. Now in that bail summary, the Home Office writes down your immigration history in the United Kingdom and also writes down its objections against your bail application, against your sureties, etc. Now, once the tribunal receives your application form and sends it to the Home Office, thereafter it has 72 hours within which it seeks to list your bail hearing in front of a single first-tier tribunal judge. It is therefore advisable that on the day of the bail hearing, you should reach the tribunal in good time. If the applicant is detained in the immigration detention, then it's not necessary all the time that he would be produced in person before the first-tier tribunal judge, because most of the detention centres are linked with the first-tier tribunal via a video link. The sureties are advised to reach the tribunal in good time, at least half an hour before the start of the hearing, so that they can meet the barrister. The barrister will check their documentation and also explain to them the procedure in the bail hearing. Your barrister would also have a chance to have a video link conference with you before the hearing, and it's always advisable to discuss with your barrister the contents of your bail summary. If you disagree with some of the contents, point them out to your barrister and explain to him that what is it that you disagree with and why. Once the hearing starts, then the Home Office is represented by its presenting officer, and the judge in the bail hearing, most of the judges, they try to decide the bail hearing into two stages. In first stage, the judge is likely to decide whether you should be granted bail in principle. That means that the judge will look at your immigration history in the UK and will also look at the continued basis of your stay in the UK. You may have an application for leave to remain or visa pending with the Home Office, or your appeal is still pending before the first-tier tribunal or upper tribunal, and you may have an asylum claim, may have a human rights claim. So the judge will have a look at that. If the judge decides that you should be granted bail in principle, then your sureties would be invited to give evidence. If the judge decides that you should not be granted bail in principle, then that would be the end of the matter and the sureties would not be required to give evidence. Suppose the judge decides to grant you bail in principle, then your sureties would need to give evidence one by one. They have to produce their original documents to the judge. That's their passport, salary slips, bank statements, tenancy agreement, utility bills and other documents. Sureties must make sure that they are aware of the bail address. That means the address where the applicant is supposed to live at. they must make sure that the applicant reports to the Home Office whenever he is required to report to. If the surety suspects that the applicant is going to abscond or not going to comply with his bail conditions, then they are duty bound to inform to the Home Office as quickly as possible. Lastly, the sureties must make sure that they have the sufficient amount of money to which they put themselves as surety. It doesn't mean that they have to pay that money in advance. That money may be £500, £1,000, £1,500 depending on the case. It doesn't mean that that money needs to be paid in advance either to the Home Office or to the First State Tribunal. It only means that if the applicant fails to comply with the conditions of his bail, only then the surety's money shall be forfeited. If the judge is satisfied with suitability of the sureties, then he will order the applicant to be released on bail, and the applicant shall be released the same day, unless if the judge orders the applicant to be tagged and monitored electronically. So in that situation, the release shall be delayed for another 2 working days, within which the Home Office shall be installing the tagging equipment at the applicant's bail address. So friends, you may have noticed that I was struggling hard to explain to you in this short presentation the procedure at the bail hearing. For the purpose of this presentation, that is it. In another presentation, I shall come with another topic. Till then, take care. Goodbye.